Welcome on behalf of the Indigenous Civil Studies program here at UBC at Allard. And also just want to recognize that we're on the unceded and ancestral territories of the Musqueam people, their traditional lands, and looking forward to a very nice.
Good afternoon, everyone, and thank you very much for coming to this event. I want to thank the Indigenous People Studies and the Center, well, not the Center, Middle East Studies, as well as the Center for Comparative Muslim Studies at SFU for co-sponsoring this talk this afternoon. And my name is Brenna Bandar. I'm an associate professor in the law faculty. I'm going to introduce our moderator, who will then introduce our speaker. And what we're going to do in terms of the running order is Professor Imseis will speak for 25 or 30 minutes or so, and then Professor Avi Lewis will engage in conversation with Professor Imseis, and then we will have a Q&A. So just to introduce Professor Avi Lewis, he's an associate professor in geography at UBC and an executive committee member of the UBC Center for Climate Justice. From 2018 to 2021, he lectured in journalism and media studies at Rutgers University. His first career in journalism spanned writing for national news outlets to directing and producing theatrically released documentaries and hosting and reporting for TV networks worldwide. In 2017, he co-founded Belief, a grassroots climate organization launched to upend our collective response to the crises of climate inequality and racism. Avi Lewis is also a founding member of the Jewish Faculty Network, UBC, and has been very active recently in supporting the struggle for Palestinian self-determination and freedom. So with that, I'd like to welcome you, Avi, and I'll hand back your glasses.
We are truly blessed to have an opportunity tonight to hear from a foremost expert on the very questions and bodies which occupy the world's attention for good reason in this unique and horrendous historical moment. Today, as I'm sure everybody here knows, Israel defended itself in the International Court of Justice against the charge from South Africa of inciting, failing to prevent, and enacting genocide in Gaza. A punctuated climax to 56 years of occupation on the West Bank and in Gaza, and 75 years since the Nakba founding of the State of Israel. So today, as we slide in tonight, in this extremely cold environment, in so many ways, we have an opportunity to both zoom out and refocus on the underlying issue of the occupation and of its long, undefined status under international law. And to get, not only to do that, but to get expert analysis of today's news from a legal expert who has long followed both challenges to the ICJ and Israel's various policies and actions over many, many years of study, scholarship, and practice in the field. And that, of course, is Dr. Ardi Imseis. He is, now I'm going to read his bio. I just want to say before I do that getting this opportunity to just engage with Ardi's work, as I'm not a legal scholar, it's not my field, or a particular, like a special interest. I've just been blown away and learned so much preparing for this event that whatever your level of familiarity with his body of work, you are in for a treat. You're going to learn like 25 things that blow your mind tonight. And I find that incredibly exciting. Ardi is an assistant professor of law in the Faculty of Law at Queen's. He's a former member of the group of eminent international and regional experts of the UN Human Rights Council Commission of Inquiry into the Civil War in Yemen. That took place in 2019 to 2021. For a dozen years, starting in 2002, Ardi served in a senior legal and policy capacities in occupied Palestine with UNRWA, which of course is the UN relief agency in Palestine. He's also, probably the most exotic of his accomplishments, senior legal counsel to the Chief Justice of Alberta.
That was nice.
Thank you. And has provided expert testimony in his personal capacity before various high-level bodies, including the UN Security Council, which has a very big role in events today, and to members of the UK House of Lords and the French Senate. His scholarship, of course, has appeared in a huge variety of international journals, like the Harvard International Law Journal and the Oxford Journal of Legal Studies. And on the particular subject of Palestine, Ardi was the editor-in-chief of the Palestine Yearbook of International Law for more than a decade, from 2008 until 2019. And he's just put his expansive experience to work, both as a functionary within the UN system and as a scholar of it from the outside, in this important, just-released book, The United Nations and the Question of Palestine: Rule by Law and the Structure of International Legal Subalternity. Terms we are going to dig into tonight. It is a revelatory and magisterial work that is the result of a decade of study and writing, and the benefit of which we all share in having him with us here tonight.
He's so generous.
Dr. Ardi Imseis. The podium is yours.
It's much too generous. Thank you. It is an absolute pleasure to be with you today. I should like to begin by extending my great gratitude to, first and foremost, Brenna Bandar for inviting me to the UBC. Brenna was also a discussant at the Simon Fraser University yesterday, where I presented my book in what was my first book launch here in Canada. I'll be doing a number of these over the course of some weeks. Special thanks, of course, to Professor Avi Lewis at SFU, who made it possible for me to come to SFU, and obviously to Vancouver, who's facilitated all of this, to the university there. Without Adil, none of this would at all be possible. And of course, to the inimitable Avi Lewis for engaging today. I'd like to thank Avi for inviting all of you here. I'm rather certain that but for his presence, I probably would have spoken to about 5 people in the room, so there you are. Avi, thank you. I suppose the best place to begin is to say that it's a delight to be here, and that it's an understatement to say that much has transpired in the past 48 hours that bears on today's talk. When I was originally invited to address you, it was suggested that I speak to you about an issue that is presently before the International Court of Justice, and that case concerns the legal consequences of certain Israeli practices undertaken in the occupied Palestinian territory since 1967. As per a legal question that is now before the court, which we'll get into in a moment. It was put before the court in December 2022, December 30, in fact, 2022. In the interim period between the time that I agreed to come and the time that and now, of course, we know that South Africa has instituted proceedings against the State of Israel, invoking the Genocide Convention and arguing that Israel is engaged in genocide in occupied Gaza following the events that took place since 7 October. And so it's almost impossible for me not to address those issues today. I, again, will address them piecemeal after I talk to you about what I came here to talk to you about. They're related, but also distinct cases. Mm-hmm. And because it's so fresh, I watched the Israeli submissions this morning. I watched the South African submissions yesterday. I've had the benefit of reading the South African submission. I've yet to read the Israeli submission. It wasn't available to me this morning when I was preparing. I'll offer you my preliminary views on that, and happy to take questions and discussion with Avi. So in keeping with my original plan, I'll talk to you about the case that is pending before the ICJ on Israeli practices. Yeah, that's the shorthand for it. If you look at the ICJ website, you'll see it's referenced under that term. The Israeli practices in the occupied Palestinian territory, including East Jerusalem since 1967. That is the title, the style of cause of the case. Yes? So since 1967, Israel has been in foreign military occupation of the West Bank, including East Jerusalem and the Gaza Strip, otherwise known in the United Nations as the occupied Palestinian territory. And since the 29th of November 2012, the State of Palestine. Under international law, occupation of enemy territory is meant to be temporary and occupying powers may not rightfully claim sovereignty over the territory that they occupy. For example, Russia is now in Ukraine. As an occupying power, Russia may not claim lawfully sovereignty in any portion of Ukraine, and thus the proper, robust response of many folks who've argued that Russia cannot claim sovereignty there and needs to leave, and so on. But despite this law, since 1967, Israel has systematically altered the status of the occupied Palestinian territory with the publicly declared aim of annexing it de jure or de facto in the intervening 56 years. The Palestinian people's right to self-determination in the occupied Palestinian territory has been recognized by the United Nations, whose position has been held out as forming the only normative basis for its realization. Central to this, the United Nations has undertaken considerable documentation of individual violations of international humanitarian law, that's the law governing armed conflict, and international human rights law, the law governing the relationship between states and individuals who are subject to their effective control, by the occupying power, and yet the United Nations has paid scant attention to the legality of the occupation regime as a whole, and the concomitant duty or requirement that it be brought to an end unconditionally in line with UN practice and the law governing state responsibility. I know I'm throwing a lot at you. How many of you, by show of hands, do international law? Wonderful.
Good to know your audience.
That's good. So I've thrown up to you various bodies of law. IHL, the law governing armed conflict. Human rights law, as I said earlier, each one of you enjoy ostensibly human rights law vis-a-vis the state in which you live. The law on state responsibility is effectively that body of international law that governs consequences of the commission by states of wrongful acts. We call these internationally wrongful acts, and so on. So under the law of state responsibility, an unlawful situation, whether the violation of a human right, or in this case, an unlawful occupation, may not be, the end of it may not be made subject to negotiation. It's sort of like, if I were to steal your watch, and then the police require that I give it back to you, but only after I negotiate the terms on which, and indeed whether I give it back to you. It's absurd. Yeah? So this is what we're dealing with, these bodies of law. So the UN practice and the law governing state responsibility on illegal occupations is very clear. Illegal occupations must end forthwith and unconditionally, much like Russia's illegal occupation of Ukraine and the solid position taken by the West in respect of that. Instead, emphasis has been placed by the United Nations on encouraging the parties in Israel-Palestine to engage in unbalanced and completely not functional, non-existent negotiations in order for the Palestinian people to be able to exercise their right to self-determination. It's absurd, really. One consequence has been for the UN to have provided a measure of legitimacy to Israel's occupation of the occupied Palestinian territory at a time when the organization has been pivotal in developing a universally binding international legal proscription against all forms of alien domination, subjugation, and exploitation. I argue that through the United Nations' failure to consistently and clearly identify Israel's prolonged occupation of the West Bank, Gaza Strip, and East Jerusalem as illegal, the UN's position on the OPT runs counter to its own stated aims of protecting the international rule of law, including as it relates to the Palestinian people, whom the very same UN, ironically so, has consistently and for decades affirmed Palestinian people's right to self-determination in the occupied Palestinian territory. You can see the tension there, right? So in furtherance of these ideas, I wish to cover the following 3 points. First, I will summarize the UN's position on the occupied Palestinian territory since 1967 and why, counterintuitively, it is deficient from an international legal perspective. Second, I will explain why, on the basis of the United Nations record itself, Israel's occupation of the occupied Palestinian territory is now unlawful, and what the legal consequences of that determination require under international law. Third, I will discuss why the case before the International Court of Justice, not the South African matter, but the other one I've mentioned to you, can help resolve what, according to the United Nations Commission of Inquiry on Israel-Palestine, led by very famous Nabi Pillay, South African Supreme Court judge and former United Nations High Commissioner for Human Rights, has characterized as one of the root causes, the occupation, one of the root causes of the Israel-Palestine dispute. I highlight the word one or a root cause. There are a good number of others, to be sure. A review of the UN record demonstrates three overarching and interrelated aspects of the United Nations management of the question of Palestine in the post-1967 era. First is the increased recognition of Palestinian legal subjectivity within the United Nations as a consequence of global decolonization over the 60s and the 70s and the 80s. Second is the proliferation of UN machinery focused on what I call the humanitarian or managerial documentation of IHL and human rights violations by the occupying power. And third is the UN's conditioning of the end of Israel's occupation on negotiation. So I'll take each of these in turn. First, in the decade following the emergence of the Palestine Liberation Organization in 1964, the General Assembly recognized, quote, the inalienable rights of the people of Palestine, end quote, including the right to self-determination, national independence, and sovereignty, affirmed the denial of Palestinian rights as the main impediment to peace, and granted the PLO observer status in the General Assembly, including the right to participate in the deliberations of the Assembly and on the question of Palestine in plenary meetings. The 1988 recognition of Israel by the PLO resulted in permission to use the designation Palestine, quote unquote, in the organization, and greater rights to participate in the General Assembly as a matter of process. And following Palestine's failed membership bid in the United Nations in 2011, an upgraded status in the General Assembly was a result, moving Palestine to non-member observer state, thereby allowing it to accede to various treaties, multilateral treaties, including the main IHL, humanitarian law treaties, main human rights treaties, say the Convention on the Elimination of All Forms of Racial Discrimination or Discrimination Against Women, as well as the Rome Statute of the International Criminal Court, and so on. Treaties that are only open, of course, to states. This increased recognition of Palestinian legal subjectivity at the United Nations has grown, the pinnacle of which is the regular affirmation of the Palestinian right to self-determination in the occupied Palestinian territory, a position reaffirmed expressly and impliedly by each of the principal organs of the United Nations. The United Nations has 6 principal organs: 2 political, Security Council, the General Assembly. It also has the Economic and Social Council, which is made up of members of the General Assembly, I think 47 or so countries. The Trusteeship Council, which is effectively a dead letter. The Secretariat, headed up by the Secretary General, who's the Chief Administrative Officer of the organization. And finally, the principal judicial organ of the United Nations, being the ICJ, the International Court of Justice. So the right of the Palestinian people to exercise self-determination in the OPT has been affirmed by each of the relevant, not the Trusteeship Council, each of the relevant principal organs of the United Nations. Second, since the decolonization era, there has emerged a proliferation of UN machinery devoted to the documentation of IHL and human rights law violations by the occupying power in the OPT. Despite the broad scope of this machinery's cataloging of the occupying power's IHL and human rights record in the OPT, it's notable for its conspicuous failure to definitively address the legality of Israel's very presence in the occupied Palestinian territory. For any of you who would like to consult just some of this stuff, you might have a look at the International Court of Justice's website, have a look at the case that I'm going to refer to, the legal Israeli practices case, if you like, and you'll see that a great deal of information has been put before the court by the Office of Legal Affairs of the Secretary General of the United Nations. Thousands and thousands of pages of documents, resolutions, and the like, detailing what I call the humanitarian and managerial approach that the UN has taken over many years of occupation. Although occupation is meant to end under international law and be temporary, not 56 years, nothing in the conventional IHL or human rights law framework paradigm expressly compels that result. Rather, its adherence to these norms merely operates to enhance the manner in which occupation is administered, pending its eventual end. Thus, by focusing on the international humanitarian and human rights law framework, instead of failing to definitively identify Israel's occupation as unlawful as such, the UN has privileged a humanitarian or managerial approach to the OPT over a remedial or emancipatory one. This has ultimately lent Israel's presence in the OPT some legitimacy. Third, and perhaps most important, has been the United Nations position that the end of Israel's occupation of the OPT must be contingent on the conclusion of negotiations between it and the PLO. This is a universally held position among each of the relevant 5 principal organs. I say 5 because the Trusteeship Council is not relevant. It doesn't deal with Palestine. Most recently affirmed by the Secretary General of the United Nations, Antonio Guterres, where he said he's gone so far as to assert that negotiation is, quote, the only way to achieve the inalienable rights of the Palestinian people. While it is true that the UN's call for negotiation covers matters beyond the OPT as such, to the extent that this negotiations condition, that's what I call it, also qualifies the UN's position on ending the occupation itself, it is fraught with a telling paradox, because the occupied Palestinian territory has been determined by the United Nations to be the territorial unit within which the Palestinian people are entitled, and exclusively so, entitled to exercise their right to self-determination under international law. The result has been for the UN to have frustrated, and on its own terms, the very recognition it has bestowed upon the Palestinian people to self-determination. If realization of Palestinian self-determination in the occupied Palestinian territory is a long-established right in the nature of a peremptory norm of international law, derogation from which is not permitted, I'll put a pin in my talk and just give you the following. In international law, there are many norms, of course, and rules. And as you know, as law students and people of the law, women and men and others of the law, you'll know that some rules can be derogated from in times of public emergency or what have you. Take, for instance, human rights law and the right to freedom of association. Article 4 of the International Covenant on Civil and Political Rights allows states to derogate from this right or adherence to this right in times of public emergency. So there are some rights, many rights, that can be derogated from. The thing is, under international law, there's also a small number of rights, principles of law that we call peremptory, that are, well, peremptory. They're automatically and always, under all circumstances, applicable, and you may never derogate from them. And you can name them on 2 hands. The obligation to respect the people's right to self-determination is one of them. The prohibition on genocide is another. You would have heard that in the submissions made by the South Africans yesterday. The obligation to ensure not engage in slavery or piracy. The prohibition on torture, right? There are a few others. And so this is at the heart of this paradox, is that the prohibition on violating a right of peoples to self-determination is peremptory, derogation from which is not permitted. How can the realization of this right be left to negotiation between an infinitely more powerful occupying power operating in bad faith, manifestly so, and based on the United Nations record? I'll explain why they're acting and how they're acting in bad faith in a moment. And those who are subject, the beleaguered people who are subject to their rule, now going on half a century, a rule that is meant to be temporary under international law. Makes no sense. So understanding why Israel's prolonged occupation of the OPT is illegal requires consideration of 3 branches of international law. The law governing the use of force is the first. We call that the jus ad bellum, or in short, ad bellum law. The law governing how force is used in armed conflict. So once you have an initial resort to force, then there are obligations to maintain certain principles. We call that humanitarian law, or jus in bello. And then international human rights law, including the law on self-determination, which is part of human rights law. And because of the OPT status as an occupied territory, the starting point must be the law of occupation, which is part of IHL, that second branch, international humanitarian law or the law of war. Now, two fundamental principles underpin the law of occupation. First, occupation is a temporary condition during which the occupying power may act only as de facto administrator of the territory for the benefit of the protected population, that is the civilian population who live there, and who are not its nationals. Yeah? In this case, it would be the Palestinians living in the OPT. Under no circumstances may an occupying power permanently alter the status of the territory, including through annexation, population transfer, or imposition of regimes inimical to humanity as a whole, for example, racial discrimination and apartheid. Second, under no circumstance does the fact of being in occupation of a territory entitle the occupant to sovereignty in that territory, contemporary state practice, exemplified by the 2003 occupation of Iraq and Russia's occupation of Ukraine, for instance, affirm that the law of occupation defers to the principle of self-determination of peoples and its corollary that sovereignty lies in the people of the territory, not in the occupying power. These fundamental principles are in turn rooted in the protection of at least three peremptory norms of international law, again, derogation from which is not permitted. The first is the prohibition on the acquisition of territory through force, that is, the prohibition on territorial conquest. It's probably one of the most important rules of international law since World War II, and it is a corollary of Article 2, subsection 4 of the United Nations Charter, which is the most important rule in international law since 1945, and it prohibits the use of force. So if the use of force is prohibited in international relations, save and except in two exceptions, or maybe three, self-defense and others, to acquire territory through force, and even in self-defense, is unlawful. The second peremptory norm, the obligation of states to respect the right of peoples to self-determination, I've said enough on that. And third, the obligation of states to refrain from imposing regimes of alien subjugation, domination, and exploitation, inimical to humankind, including racial discrimination. In short, and according to the UN record itself, and this is where my research looks, the UN record is the one that's establishing all of these things. Yeah? Israel's 56-year occupation of the OPT has been maintained in violation of these peremptory norms, upon which I shall offer a brief comment now. And as I do, I should like to call your attention to the fact that at the heart of these violations, these three violations, runs a single theme and policy, and that is Israel's policy to transfer its own civilian nationals into the territory of the occupied population, the occupied Palestinian territory, for the purpose of colonizing it and maintaining and asserting an exclusive right to Israeli sovereignty in this foreign territory. Yeah? That's the thing that runs throughout all of these. So since 1967, a bit of empirical factual information now, all of which is derived from the UN record. Yeah, none of this is really controversial. Since 1967, Israel has annexed both de facto and de jure a substantial portion of the occupied Palestinian territory through a series of legislative, administrative, and other acts in contravention of the peremptory norm prohibiting the acquisition of territory through the threat or use of force. Thus, when Israel attempted to formally annex occupied East Jerusalem in 1980, both the United Nations General Assembly and the Security Council affirmed prior determinations that such a move was, quote, invalid, and decided that, quote, all member states are obliged not to recognize Israel's attempt to alter the character and status of Jerusalem, as an example. Keep this in your minds, friends, because with the conservative takeover in Ottawa, one of the very first, they promised this, one of the very first foreign policy things they're going to do is recognize occupied Jerusalem as the capital of Israel, as the United States has. This would be a violation of Canada's obligations under international law not to recognize violation of peremptory norm of international law by an occupying power. We wouldn't recognize Kiev as the capital of the Russian Federation, and we shouldn't do in occupied Palestine as well. Beyond Jerusalem, Israeli actions elsewhere in the occupied Palestinian territory have effectuated its annexation in all but name. This includes the expropriation of large segments of territory for Israeli settlements and related infrastructure. This includes bypass roads, electrical and sewage grids, tunnels, checkpoints, etc., roads, as well as the construction of the now infamous wall and its associated regime declared illegal by the International Court of Justice in 2004. As noted by a UN fact-finding mission, each Israeli government since 1967 has, quote, openly led and directly participated in the planning, construction, development, consolidation, and or encouragement of settlements, end quote, in the occupied Palestinian territory through various political, military, and economic means. Today, according to the UN Secretary General, between 19 and 23% of the population of occupied Palestine, that is the occupied Palestinian territory, are themselves Israeli settlers. They're unlawfully put there by the occupying power. Israel's violation of the Palestinian right to self-determination in the OPT has equally been driven by its settlement policy. According to the International Committee of the Red Cross, which is the custodian of the laws of war, one of their early legal advisors, his name is Jean Pictet. He wrote the commentary, the authoritative commentary on the Geneva Conventions of the Laws of War. According to Pictet, the prohibition codified in Article 49 of the Fourth Geneva Convention on Civilian Settlement of the occupying power, by an occupying power, was, quote, intended to prevent demographic changes to the occupied territory, quote, for political and racial reasons, end quote, and to frustrate attempts to, quote, colonize such territory. Yet, according to the UN record, that is precisely what has happened in the occupied Palestinian territory since 1967. Thus, in 2012, the Secretary General reported that, quote, the current configuration and attribution of Israeli control over the land in the occupied Palestinian territory severely impedes the possibility of the Palestinian people expressing their right to self-determination. He noted that, quote, because the settlements are scattered across the West Bank, including East Jerusalem, the territory of the Palestinian people is divided into enclaves with little or no territorial contiguity, with a resulting fragmentation that undermines the possibility of the Palestinian people realizing their right to self-determination, end quote. Finally, Israel's settlement policy has introduced a system of government in the occupied Palestinian territory that, according to the UN record, is systematically engaged in racial discrimination, as proscribed in the International Convention on the Elimination of All Forms of Racial Discrimination. We call this CERD, to which Israel is signatory without reservation. Israel's view that international human rights law, and this has been affirmed by their Supreme Court, including CERD, does not formally apply to the OPT, has been rejected by the United Nations, including the principal judicial organ, the ICJ, the International Court of Justice. This racial discrimination underpinning the regime Israel has erected through the imposition of exclusively Jewish settlements in the OPT is systematic and widespread. As such, in its concluding observations on Israel's 2012 periodic review, the Committee on the Exercise of the Elimination of Racial Discrimination, observed that Israeli settlements in the OPT, and I'm quoting now, are an obstacle to the enjoyment of human rights by the whole population without distinction as to national or ethnic origin, end quote. It declared, quote, extreme concern, end quote, with Israel's policy of, quote, de facto segregation and the, quote, hermetic character of the separation of the two groups, concretized by a complex combination of movement restrictions that only impacts the Palestinian population. Palestinians can't get around the occupied Palestinian territory without a permit from the Israeli military governor. I'd lived there for 12 years, and so you can't, it's very difficult to get a permit to move around. So this territory is fragmented, and only for the Palestinian population resident in the West Bank or East Jerusalem. It declared extreme concern with the policy of de facto segregation, as I had mentioned, the hermetic character of the separation of the two groups. And these findings were subsequently echoed by a UN fact-finding mission which decried, quote, the legal regime of segregation, end quote, in the occupied Palestinian territory, enabling, quote, the creation of a privileged legal space for settlements and settlers while violating Palestinian rights to non-discrimination, equality before the law, equal protection of the law, etc. The racial discrimination in Israel's settlement regime in the OPT has given rise, as many of you know, to concern that it is also engaged in the crime of apartheid, a view now publicly shared by Human Rights Watch, Amnesty International, Israel's own leading human rights organization, B'Tselem, Palestine's leading human rights organization, Al-Haq, and many, many others. That issue is now before the International Court of Justice in the case that I'm talking to you about, and we will have to wait and see what the court says on that. As none of these apartheid studies, of course, represent the view of the UN, The organization, that is the UN, has yet to make a definitive pronouncement on the issue of racial apartheid, certainly, in the OPT. So we'll see what the court says. So why does legality of the occupation even matter? That might be a question you ask, and it's important to answer it. And it goes to state responsibility that I spoke about earlier. At the heart of the issue is the tension between the UN's position on the occupied Palestinian territory with the relevant international law governing state responsibility. On the one hand is the political consensus that the emergence of an independent Palestinian state in the occupied Palestinian territory can only arrive through negotiated withdrawal. On the other hand is the relevant international law concerning responsibility of states for internationally wrongful conduct, an elemental foundation of which is the proposition that states may not negotiate the consequences of their illegal actions. Ex injuria, jus non oritur. Illegal acts do not give rise to legal rights. So under the law of state responsibility, it's rather simple. The legal consequences of Israel's illegal occupation, or indeed any states for that matter, not just merely Israel, internationally wrongful acts are threefold. First, states must immediately cease the action, forthwith and unconditionally. Second, they must make appropriate representation of assurances of non-repetition. And then third, they must make appropriate recompense, reparations for the illegal actions. Because states may not do collectively that which they're prohibited from doing individually, these obligations attach sometimes to collective actors, particularly where you have peremptory norms engaged, where given the occupation involves gross and systematic breaches of jus cogens norms, additional consequences for third states, including Canada, require them to cooperate, firstly, to bring the occupation to an end through lawful means, and to refrain from rendering any aid or assistance in maintaining it. That includes non-recognition, right? All this to say, the UN's conventional approach of conditioning the end of Israel's illegal occupation of the OPT on negotiation is problematic. It runs counter to the prevailing international law on state responsibility, where an occupation has been determined by the UN to be illegal. Obligation to bring it to a speedy end has never been conditioned on negotiation. It also renders conflict resolution more difficult by providing a measure of legitimacy to illegal actions. So let's talk about the case. Last December 2022, forgive me, not last December, a little bit over a year ago, the General Assembly under Article 96 of the United Nations Charter put a question to the court. And the question put by the court to the principal judicial organ of the United Nations is as follows. See Resolution 77/247, I think it is, 30 December 2022. Paragraph 18 of that resolution, entitled Israeli Practices in the Occupied Palestinian Territory, has put the following question to the court. A, two-part question. A, what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem, and from its adoption of related discriminatory legislation and measures. Part B, how do the policies and practices of Israel referred to above affect the legal status of the occupation, and what are the legal consequences that arise for all states and for the United Nations from that status? Big questions. Effectively, the nub of it all is whether or not Israel's continued presence in the occupied Palestinian territory is lawful. And if the court follows the record established by other principal organs of the United Nations, of which it is the principal judicial organ, the conclusion, in my respectful view, and I can't put my hands on a crystal ball, would that it were that easy, will be negative. That is to say, Israel's presence there will be declared to be unlawful. Why does this matter? We can talk about South Africa, but the heinous acts that took place on the 7th of October, the harrowing acts, really, we all watched them on TV, and these actions were horrible. I, just as a matter of public record, have to say that openly. Did not, and I'm quoting now, Antonio Guterres, the United Nations Secretary General, did not happen in a vacuum. People have to ask, wherever do these acts, these violent acts come from? History did not start on the 7th of October. If you've taken anything away from today's discussion, you'll know that there is a history here, and to be sure, that goes well beyond, well past, deeper than I've relayed here. I can talk to you, and perhaps if you read my book, you'll learn more about the history of the question of Palestine. It goes back about at least 120 years or more, slightly more. But that is to say, we must contextualize actions in the world and resist, in my respectful view, the desire of some to separate issues, basic issues, that we're all familiar with as humans. Separate issues as between cause and effect. It's easy in the post-September 11th world to look at horrible acts that are terroristic and treat them somehow as isolated from power, politics, culture, history, to treat them as though they operate in a vacuum themselves, that history began with the actions of those desperate souls who commit horrible actions. That's just anti-intellectual. It makes no sense. We know that from birth. Cause and effect is a marked feature of what it means to be a human. So, when looking at events now in the South Africa case, just keep in mind, and the court will most definitely be having to keep in mind, and the South Africans have called that before them, about the larger context here. There is a foreign military occupation. Israel asserts exclusive sovereignty in that territory. That claim is legal. Israel is engaged in widespread and systematic actions that amount to crimes against humanity. I've described those there. War crimes, certainly. And quite possibly, if you are in the foreign ministry at South Africa today, as alleged by them, genocide in the Gaza Strip. And so, it behooves us all to be critical about what's happening. I think that's a good space to stop, Avi. Engage with you, and then the others in the room. And I'd like to thank you for the opportunity to present my thoughts to you today. Thank you.
Can I borrow your watch? I just never had one of my own.
Sure.
And I just really, really need one.
That's fine. There you are.
Great. So we really got to talk about you getting your watch back.
Are you sure?
I could maybe do like the second hand
Do you think?
under certain circumstances. But
Let me give it some
the
thought.
only way you can get this back is by negotiating. Piece by piece. I just can't, I can't believe, some of the things that you have taught me sort of blow my mind. So I want to start with a couple of ideas, just at a sort of populist level, and then we got to talk about what's going on in the news, and then we'll bring the people in.
Of course.
So let me get this right. The occupation itself, I was born a few weeks before the 6-Day War. So it's been going on my entire life. There's never been a ruling?
Okay, great question. The short answer is not a ruling of the principal judicial organ, nor of any other court. Interestingly, and you'll have to read the book that I've just written and some of my articles on there, it's available at a fine bookstore near you, to be sure.
An independent bookstore, obviously.
Yeah. As it happens, between the year 1977 and 1981, the General Assembly of the United Nations qualified the occupation, that would say, from the 10th year of the occupation as quote-unquote illegal. Thereafter, for another decade, they qualified it as a violation of the United Nations Charter, which implies the application of Article 2, subsection 4 of the Charter with its corollaries, meaning the prohibition on the general use of force in international relations, and its corollary that one may not acquire territory through force. So the Economic and Social Council also did the same for a good decade, maybe a bit more. So you have that practice, but it's not a judicial declaration. Those are political arms of the UN. So that's why it's vital that the court sees itself or is seized of this question. And when the hearings open on the 19th of February, I'll be in The Hague for that. And then they will likely issue a ruling in the case in July.
So what about Ukraine?
Yeah. Ukraine is a sovereign state. It has its territory. There certainly are historical claims, I understand, made by Russia, on Ukraine. But those historical claims run up against the modern public international legal system, which recognizes, for good or ill, that the sovereignty over Ukraine's self-determination unit, its territory, belongs exclusively with the Ukrainian people. So our position in Canada is quite, I think, correct, and I'm very pleased to see the position that Canadians have taken, the Americans and other such, to urge that Russia withdraw from occupied Ukraine. Russia is no more sovereign in Ukraine than anyone in this room, and that's that. The oddity there, of course, is the lack of universal application of norms by our government and other Western governments who claim a fidelity to the rules-based international legal order, but in fact apply law selectively, arbitrarily, and based on national interest.
There was an instant global.
Excuse me, you have to talk really loud.
There was a.
What you're saying.
Thank you for pointing that out. Appreciate
Yeah,
that.
really
I will. Believe me, I can project. All right. Is that better?
Yeah, that
Cool.
was much better.
There was an instant universal assumption that invading another territory is illegal, and then we saw an extraordinary coordinated response of sanctions, of financial sanctions, of trade sanctions, of other measures. But none of that was based on an international, the ICJ, or an international legal process.
Nor did it need to be, because these principles are so central to the rules-based international legal order. I use the word legal order quite deliberately there, that all states are bound to uphold them because they are peremptory, right? So we needn't wait for the International Court of Justice to declare that Israel's presence in the occupied Palestinian territory is unlawful, to know that all states, including Canada, are obliged not to engage in actions that extend recognition of Israel and its sovereignty in that territory. I'll give you an example, but it would help to have the opinion of the court because of this lack of action, right? That's the whole point of it. Canada has a free trade agreement with Israel. It's called the Canada-Israel Free Trade Agreement. Makes sense, right? Canada is one party to it. Israel is another party. And states are readily able and capable and acting as sovereign states to engage in trade with one another and make it free trade. And that's okay. But if you look carefully at the agreement, the definition of Israel under the agreement is not merely Israel and its territory, but territories where anywhere Israeli customs laws apply. I'm paraphrasing. And as it happens, Israeli customs laws apply in the occupied Palestinian territory. Right. So in effect, this is a roundabout way of basically Canada extending duty-free status to Israeli settlers and their products, right? They may produce wines and other such. You can go to the local beer store and find them there. And grant them not only preferential treatment, but more importantly, from the legal standpoint, effectively recognizing Israeli sovereignty in occupied Palestine. And under the Vienna Convention on the Law of Treaties, this is the law governing treaties, international treaties that violate peremptory norms are ab initio, that is from the start, unlawful. So Canada is engaged in an unlawful action. This is just an example of many where there's no action taken on this case when you juxtapose it with Russia and Ukraine. Well, it's astounding.
And I've been thinking about this in relation to South Africa's case at the International Court of Justice, because if the court finds that, or issues these, what do they call the
provisional measures?
Provisional measures.
Yes.
Then every other country that didn't step in, who's also a signatory to the Convention on Genocide, is legally exposed.
That's right. That's
so
right.
What are the implications for Canada? And we just had another move from our government today to not agree with South Africa's premise, whatever liberal bullshit that is.
Yeah, it was rather odd, wasn't it? Yeah, it's rather odd.
It's like a non-position, which is a very clear position, and if you read the statement, it's a bunch of talking points about Israel's right to defend itself, and a very political position.
Yeah.
But so what happens then if there's a decision of the ICJ initially that exposes Canada to some responsibility here?
Yeah, so it's a great question. And let's look at the law on genocide. I'll talk to you about the definition of genocide in a moment, but let's assume that, the law is simple. Where parties to the Genocide Convention have reasonable grounds to believe that a genocide may be taking place, not is taking place, but merely
Risk.
may be taking place, that there's a plausible case for genocide somewhere, that triggers an independent legal obligation in each of those members, including Canada, who's a signatory to the Genocide Convention, to prevent it, and to take action to prevent it. And it makes sense, you want to prevent it before it occurs, right? So the question is whether or not there's a plausible case, not necessarily that it is taking place, but that there is a plausible case that genocide is taking place. And this is the importance of the South African push. So under the Convention on the Suppression and Punishment of the Crime of Genocide, punishment and prevention of the crime of genocide, I think it is. Genocide is defined as a series of acts that when undertaken with intent to destroy in whole or in part members of a national, ethnical, forgive me with the archaic language, it's archaic, okay. It's archaic. And members of a national, and because I'm a lawyer, I'll use the same language, members of a national, ethnical, racial, or religious group as such, to destroy in whole or in part members of such groups as such, then you have genocide made out if you have these actions. And these actions include killing members of the group, imposing conditions of life on members of the group or on the group designed to destroy them in whole or in part. So you don't even need killing as such. If you impose those measures designed to kill, with knowledge that it would happen, in all likelihood, then you have an issue there.
Or to restrict births too.
Yeah, there is. So that's also an element of it, to impose measures that have an impact on restricting births among the group. The South Africans have pressed that, and there are a good number, thousands of Palestinian women now who are unable to give birth or are giving birth in very, very difficult circumstances, C-sections without anesthetics, and children are dying and so on. So they're making that case. Now, understand the case in two phases, right? When the International Court of Justice exercises two types of jurisdiction. One, advisory jurisdiction, where legal questions are put before the court, like the one I've just mentioned by...
We need an opinion on this.
That's right. It's like a reference case in the Supreme Court of Canada system. No? Legal question put before the court, they offer their opinion. They may offer their opinion on the question. But then you have another jurisdiction, which is where there's a contentious dispute between states. And this is the type of matter that is before the court in South Africa and in Israel. So in any contentious case where issues before the court are pressing in time, sometimes a party to the case will ask for provisional measures. And this is effectively an injunction, for those of you who know the domestic law. The idea is to get a hearing quickly. And the aim of the injunction or the provisional measures order would be to freeze or preserve rights of the parties, freeze and preserve the interests of the subject matter of the litigation, so that none of those things are prejudiced as the merits of the case take place some 2 or 3 years later, because you'll need evidence pulled in, you'll need to contest that evidence, and those processes take time. But of course, we're dealing with genocide. And so the idea is to stop the fighting in order to stop the killing. And, let's preserve their lives.
It's important to remember the South African case is out of date by the time it's filed.
In effect.
Because every single day, bombs continue to fall.
In effect. So why does all this matter? Well, the test on a provisional measures order, as you might have heard, is not whether or not it's genocide. The merits phase has nothing to do with it. That happens in a couple years from now. It's whether or not there's a plausible case of genocide. Mm-hmm. And if it's plausible, Avi, then once the court issues an order, which it will in the coming 2 weeks, and in my respectful view, I mean, again, I don't have the crystal ball, but in all likelihood, it's going to issue an order saying that there is a plausible violation by the occupying power, Israel, of the Genocide Convention, plausible. Once that order comes down, then no third state, including Canada, can pretend that it does not know it's happening, and that triggers the duty to prevent. That requires action taken on the part by third states to act politically, economically, diplomatically, in different ways vis-a-vis the occupying power, who may be, according to the court, engaged plausibly in genocide. It would be different, of course, if the court doesn't issue provisional measures, and they may not. Mm-hmm. But knowing the jurisprudence and knowing the facts and seeing what I've seen and all the evidence, which is in the public realm, if I were a betting man, I would say they're going to issue the order.
So now we have to get into the fundamental question of whether international law matters.
That's my cue to leave. I
Yeah,
think.
no, bye. And it is striking to me that people studying international law and scholars in international law here at the school are not here tonight. I'm disturbed by that.
I don't know who people at UBC are.
I'm not trying to
my
call
two
anybody
friends.
out or
Yeah.
in, but I'm just saying like this would be maybe a central question of international law right now. But
Yeah.
It is a central question.
you might think. The character of the occupation for 56 years and the inability for anyone outside to change the facts on the ground, as Ariel Sharon called them, is the impunity of Israel and the protection of the United States.
Say again, is
The impunity of Israel and the protection of the United States, that nothing so far has succeeded in changing the practices. I mean, I was really struck by your analysis that the international legal system and the UN have been very good at documenting all of the violations of international human rights law. The facts on the ground have been evaluated, they have been condemned, they've been judged. The underlying legality has not actually been remedied
Yeah.
or even recognized.
Yeah.
So now we're in the world of realpolitik. The ICJ comes out with something. Let's say your bet is right. And I think we all know what will happen. Israel and the United States tried to preempt this whole case by saying Israel, of course, calls it a blood libel, and the United States says there's no merit before the case has been heard.
Yeah.
And U.S. contempt for international law and legal norms is a feature of U.S. foreign policy, so we're familiar with both. So what advantage is there in this process?
Sure. And so the question effectively is going back to the initial one, does international law matter? A big question, a question that I deal with all of my students in the first day of class in public international law. International law is different than domestic law, where you have, say, ideally a division of powers. In the domestic realm, you would have the executive, you would have the judiciary, you would have the legislative. And there is a robust system in the domestic level of enforcement of law where it is broken and so on. It's not to say that it is always enforced, but it's just more robust. On the international legal plane, you don't have the same separation of powers. The states create law and at the same time are bound by it. And to quote my old professor, Louis Henkin, who taught me at Columbia Law, Professor Henkin, who actually drafted the Universal Declaration of Human Rights in 1948.
Oh, that guy.
Yeah, that guy. Louis Henkin used to say to us, he'd say, international law is unique. Most states follow most of their obligations most of the time. That is to say, sometimes they just don't. So what to do? And the United States and Israel are not unique in this regard at all, in respect of certain things that they don't follow and so on. They follow
Well, Saudi
others.
Arabia is a big fan of international.
Yeah. So the question is, what value law? And the value is that law presents a picture of what is regarded as legitimate in the international relations realm, in the international life, if you like. So that can then be used extra legally. Law is not merely something that is black letter and done in a courtroom. We're doing law right now. We're talking about law. And you might feel compelled to act as a result of what I hear that has nothing to do with doing anything in a court. And states can do the same thing, right? They can implement policies in furtherance of their beliefs that, what is wrong, and their sense that what is happening is wrong, and they're obligated to act. And there are 195 states, 96 states, so they can each individually act. The South African push may or may not result in an end of the genocide that is apparently taking place in Palestine right now. But what it will do is activate other mechanisms, both legal and extra-legal, across the world in ways that we've not seen before in the question of Palestine.
There could be other cases, there can be...
Absolutely. Indeed, there are
pressures.
obligations of third states that predate October the 7th in this case to prosecute or extradite, including Canada has an obligation to prosecute or extradite persons who are alleged to engage in war crimes, crimes against humanity, everywhere, not only in the occupied Palestinian territory. The question is whether or not they're doing. So yeah.
I've been thinking about Canada's role in this because I do think that as a soft power, as the little brother of empire, we have a special place in this equation. In that, if you look at a lot of the UN resolutions over the years, you've got Israel the United States, some small island states that are essentially economic and military clients of the United States, and Canada.
Yeah.
Under this Trudeau government and the Harper government before it and the Martin government before it and the Chrétien government before it and the Kim Campbell and Brian Mulroney government before that, Canada has usually lined up with Israel and the United States.
Yeah.
Do you think that this could put a new pressure that could change the role of Canada in this global crisis, in this global dynamic? If Canada were to start taking a slightly different position at the United Nations and in the global conversation, do you think it could be significant?
I think it should be doing so, but I'm not entirely sure it will. Canada's foreign policy on this particular issue is driven primarily out of two places. The domestic interests of the ruling, if you like, authorities. So, the Liberal Party has an election coming up. They want to make sure that they do the right thing by their constituents. And there's a lot of pressures domestically by different groups who want them to do certain things. This is politics. Whatever you think of it, that's how politics is done in a liberal democracy, and that's just a marked feature of it. So I tend to think that foreign policy on this issue is driven by domestic politics. The law notwithstanding and so on. So I don't know if they'll do the right thing, but I am heartened, for instance, by the following, that those persons in a position to do the right thing, say at our foreign ministry or legal advisors to the Prime Minister's office, they know the law.
Yeah.
They know it, and we know that they know it because, just by way of example, there's another genocide case, a number of them that have been brought before the court, but there's another one that's now pending, Myanmar and Gambia and Myanmar. Mm-hmm. And just a few weeks ago, I think 3 or 4 weeks ago, Canada joined the United Kingdom, the Netherlands, Germany, the UK and France and Denmark, and put together a joint declaration to submit before the court. And the things they submitted there were extremely good, basically saying that, it can qualify as plausible genocide if you basically forcibly transfer a population through a military operation, and basically qualified a lot of the actions that we're seeing now happening in occupied Palestine as genocidal. So they know, that. And yet, as we saw today with Minister Jolie's statement, her position on the South African matter was Canada is watching it. Canada, I think, disagrees with the premise of the case. I don't know what that means. Mm-hmm. It sounds as though they disagree with South Africa's position that there is a potential genocide there. And Canada is going to be watching out for potential anti-Semitic acts here in Canada that may result from these actions.
They stuck on the word Islamophobia right at the end.
Yeah, but basically attaching to what I think is a good faith effort on the South African part to anti-Semitism in Canada. It was rather odd, but this affirms for me the position that I'm taking here in answer to your question, that these things are driven by domestic politics, mm-hmm. for good or ill. And the point is that free-thinking women and men who care about principle, about law, about life, need to put pressure on the government to do the right things and for the right reasons, and most importantly, apply law universally. If you don't apply it universally, it's not law, it's something else.
Well, I'm going to ask you one more question, then open it up to the crowd here, but it's, I get that the law is your love language.
Yeah.
I suspect that may be true
much
for
to
a
the
bunch
great
of
dismay
people
of my
here.
wife.
Yeah, I know. But there is this interplay between activism, between movement pressure, between the political battle that's going on as people have taken to the streets in huge numbers, as we've seen the formation of new groups. Brenna mentioned that I'm part of the Jewish faculty network here at UBC, a new group, and there are lots of new groups emerging as people respond to a moment in history. And I think, that the general, public, whatever that means, people are freaked out, people are not sleeping, people across society are still, people need to check out, and I think that people give themselves permission to do other things, have other realities that they have to attend to. But there's a huge number of people in our society who are gripped by this day and night. And if there is a reference to some abstract principle in international law, I feel like someone like you might be helpful for us to connect it to the things that we do. And I want to ask you about something specific, because as some of you may have seen, Naomi Klein wrote an article in The Guardian this week about the boycott, divestment, and sanctions movement, which is a call from Palestinian civil society almost 2 decades ago, that countries around the world put pressure on Israel economically, in terms of trade and sanctions, in order to, it's a non-violent, protest tool that was used by South Africa against apartheid in that struggle. And obviously people outside South Africa, but also people inside South Africa. The BDS declaration says that Israel should face consequences, material consequences from other countries in the world until Israel abides by international law. So even in this tactic, which Zionist groups around the world have made almost the movement that dare not speak its name, and we'll see in this next period whether BDS reemerges as a non-violent tactic to exert a different kind of pressure, it still makes reference to international law as the standard by which we should be fighting. And there are lots of debates within that movement about whether international law is something we should be invoking. Now it seems much more pressing when international law is brought into this conversation in a moment of horror, in a moment where 100 children are dying every single day. Yeah. And that's only one of countless horrors that we could enumerate. So I guess the question is, do you see tensions within your own invoking of international law when you are grasping for abstractions in a material situation which is the most serious that we can imagine as human beings, which is genocide?
The short answer is yes, and this is a daily occurrence and a marked feature of the life of any international lawyer. And that is because of the unique nature of international laws and its structure. It's not self-executing. It doesn't enforce itself, yeah? It requires action on the part of men and women and people of conscience. And so in order to get that action, you need to call upon other tools to press. Ideally, always, in my respectful view, those tools should be nonviolent. And this sits well with international law. The United Nations Charter affirms the importance of Pacific dispute settlement. So even though you might not like the South Africans saying you're engaged in genocide, but if they do so in a court of law, then you really have no reason not to engage. So the Israelis, for instance, are engaging, and that's a good thing, I think, in their
Would
interest.
have been different if it was the International Criminal Court.
Yeah, indeed. But in fact, it is different in the case that I've mentioned that I'm working on. The Israelis immediately dismissed the whole idea as, quote, and I'm quoting, a jihad war of Israel delegitimization. Right. So the ICJ, the principal judicial organ, is now a quote unquote terror action. See the views of the permanent representative of Israel in the 4th Committee of the General Assembly on the draft of the resolution that I'd mentioned, and you can read about it in
Sounds like we may have heard it before.
Yeah, so states are free to do that. They can poo-poo the courts, and so then that question is then what is left? And what you're seeing in the extreme is sometimes people use force. Right. And the Palestinians have tried to use force, and they're not unique. I mean, goodness, the Zionists used force in Palestine against the British long before Israel was established. I was in the Hebrew University. Oftentimes I would go and have drinks there when I was working in the occupied Palestinian territory, and there's a little coffee shop there. And there's a big sign in the Hebrew University area there that is on the campus that commemorates, it's one of those commemorative signs that you sometimes see from the government that puts up a historical sign saying, at this spot, the Haganah, the defense forces of the Yeshuv hid weapons, in this university. It's basically saying we committed a war crime and all of that. So the point is, where resistance forces use force, that is not productive. It's not right. And sometimes, as we see now, it's immoral and results in crime, and it only harms people. Why ever would you do that? Therefore, you must go for nonviolent moves like the BDS. It makes no sense to poo-poo the BDS and treat it as though it's an anathema. That is complete nonsense, and it makes no sense to me, really.
I think it was the campaign, multi-year, extremely serious campaign on a lot of different levels to delegitimize BDS, is because it was such a threat.
Yeah.
And it occupies a moral place which is so hard unless you equate it with anti-Semitism And that's always been the move.
Yeah.
But I wonder if are you in any kind of mobilizing movement spaces with your work? Because you said a bunch of things that I could picture activists debating.
I must say, I'm
eager to know if you get in that space.
I'll be self-critical. The short answer is not really. I'm not much of an activist, and my activist friends with whom I'm plugged in actually feel poorly about the fact that I don't do activism, but I do think that I try and feed into it with my work, my scholarship, my practice as an international lawyer.
Writing this book.
Yeah, doing that sort of stuff, but I've never been good at that. But I do communicate with and coordinate with those who are much more adept and better at me than in organizing, and I do also believe in it. So perhaps you're helping me feel compelled to change my way.
I feel good about that.
Yeah.
Now, so I want to, there's an overflow room because there's so much interest tonight. And I think if we use the mic for questions, then everyone next door will hear as well.
I think so.
So, I mean, giving up my mic is something like, as a former TV host, this is something I never like to do, but I'm really eager to hear people's questions. Brenna's going to check on the other room. Let's take this first question. And will you pass the mic back when you're done?
Yes. Thank you so much for the talk today. I'm interested in your opinion on the IHRA definition of anti-Semitism and its use in the current context. And IHRA, for those who don't know, is the International Holocaust Remembrance Alliance's definition of anti-Semitism, which worried people for it being used to potentially, if you're critical of Israel, if you're critical about Zionism, then you're anti-Semitic. And folks who do support the IHRA, especially bodies like the CIJA, they have continually advanced it so that it's not just anti-Semitism now, anti-Zionism is now anti-Semitism. The city of Vancouver has adopted it recently. The federal government has adopted it recently. Can people be prosecuted? Does it have any legal legs for that definition? And how does it play in the current context that we're in?
Thank you for that
Great
question.
question.
Abby, is it okay if I take it one by one?
Sure.
Yeah. Look, I tell you this, I must issue the following proviso. I am not a domestic lawyer. Indeed, I can confirm that if you speak with the Chief Justice of Alberta, she'll tell you the same thing. But I can't tell you whether or not it's justiciable. I don't think it is. I think the IHRA definition is not legal. Definition not been embedded into any legislation, certainly not in this country. There have been attempts, I think, to get it recognized in resolutions that are non-binding of certain bodies, municipal bodies, and other such. And I think that's really part of the problem as well, because it's not legal. So once the allegation of anti-Semitism is made, you really can't challenge it legally, and then you get into basically a spin in the media, and that I've seen a lot of people get caught up in that. But I think on the substance of the definition, it's problematic in my respectful view. The definition of anti-Semitism used in the definition itself, the definition proper, I think is hatred of Jews as Jews, I think. I'm paraphrasing here. That's obviously straightforward and at all not a problem. Indeed, anti-Semitism is a scourge. It must be fought against by men and women of conscience. I certainly have thought against it my whole life. I take it seriously. The problem is with these definition, the definition has attached to it, I think, 11 examples, 7 of which deal with criticism of the state of Israel in some way. So to call Israel a quote-unquote racist endeavor equates with anti-Semitism because it violates this IHRA definition. Well, I'll tell you what. If the principal judicial organ of the United Nations issues a provisional measures order in 2 weeks, saying that it's plausible that genocide may be taking place because it involves the destruction, with intent, the destruction in whole or in part of members of a national, racial, or religious group and so on, then that would make the ICJ potentially anti-Semitic.
Under the IHRA definition.
Under the IHRA definition. All this to say, I don't mean to be glib. I do think that there's a real problem with it, and first and foremost, Jews, right? because anti-Semitism needs to be properly assessed, named, called out, and addressed. But if you link to it perfectly legitimate criticism of a state, we're not now talking about Jews, we're talking about a state that holds itself out as a Jewish state, but it's still a state. And in a democratic world or society, we should still be able to hold states to account. Indeed, that's part of the game. That's part of membership in the international community, international system of states. You are a state, and therefore you have rights, duties, and obligations. So that means you hold yourself out under international law to these rules. And so does that mean that you can't criticize a Muslim state or a Jewish state because that would make you a racist, an Islamophobe, or in this case, an anti-Semite? It's patently absurd. I frankly don't pay much mind to it. I just carry on with my work, and I would encourage you to do the same.
Thanks.
Thank you. Thank you so much for this fabulous talk. I'm curious about Yemen and the role of third-party countries. Would a provisional order be needed in international law to provide greater international legal weight to disruptive actions meant to act on behalf of the people of Palestine, or is it legal as it stands right now? And if that's the case, what is the US and Canada and others doing attacking Yemen? I'm just curious about the state of that kind of intervention.
Now I see where your question is coming from. You're linking Yemen to the Palestine matter, of course, because of what's happening in the Red Sea. I pause because I'm not entirely sure I should offer an answer. I served as a member of the Yemen Commission of Inquiry in the United Nations. And we have reports that are on record, and those reports need to be maintained. Their integrity needs to be maintained. So I, with respect, won't comment on Yemen in relation to its connection with Palestine. If you like, I can talk to you and answer any question you have about the war in Yemen and the things that we found on the Commission of Inquiry in respect of crimes against humanity and war crimes and sexual violence and other such committed by all parties to that conflict, which is ravaging the people of Yemen. But I'm afraid I won't offer a response on its connection to Palestine by virtue of my independence as a member of that Commission of Inquiry.
We hit a red line. Okay, I need to attend to this side of the room. And I think we should do a round of three. So can we do focus questions, and we'll do three in a row, 1, 2, 3. Pass it back. Thank you.
Thank you for your talk. The phrase acts of genocide is a familiar expression for those who were with us in April 1994. The U.S. Spokesperson facing the question, how many acts of genocide does it take to constitute a genocide in relation to Rwanda? I would be very interested in your thoughts. Obviously, the contrasts between Rwanda and Israel and Palestine are very clear. I would love to hear your thoughts on some of the similarities. Why, again, genocide is going on, and I don't know, in my mind, it's clear, but it seems that no country will meet its responsibility to resist, to bring to an end, to prevent genocide.
Well, the South Africans certainly are.
Yeah.
But thank you for the question, and I will offer an answer.
Yeah, I think we should take three, and then you can do a round.
I'll try and remember the
Reaching
question.
the end of our time. I'll help you.
Thank you.
I'm concerned about the self-contradictory nature of international law as it applies to Palestinians and specifically to historic Palestine. So I, like many Palestinians, am concerned that when forwarding arguments to the ICJ that specifies the distinct status of Gaza and the West Bank, it tacitly reinforces and provides precedent for the legitimacy of the 1947 UN partition plan for Palestine, a partition plan that was made without consultation or consent to Palestinians, and that resulted in the 1948 Nakba.
That's in his book, too.
Yeah.
However, relatedly, the right of return of Palestinians, as it's set out in the UN General Assembly Resolution 3236, can only be realized if there is a legal acknowledgement of the fact that Palestinians were legitimately residing in 1948 Palestine, in cities like Jaffa and Lidda and Haifa, and that they were unjustly displaced from these cities.
Nice one.
Ardi, just maybe a question where I'm asking you to make two assumptions. One, that the provisional order does hold Israel to account in the next couple of weeks. The second is your knowledge of domestic law. And the question I have is around foreign fighters. So Canadian legislation, or at least the rules that I understand them, and I have no real understanding of domestic law, we encourage participation on the Ukrainian side of the conflict in terms of military, but we outlaw participation on the Russian side. Similarly, there are Canadians who are participating on the Israeli side, but if there was anyone of Palestinian descent or anyone else engaging on sort of a military aspect of it from the Palestinian side, I'm sure they'll be prosecuted. But what happens in 2 weeks if Israel is held to account and these Canadian foreign fighters over there? Is there any legal consequences that Canada has to enforce them?
Thank you. Thank you for the question, Javed. With your permission, Javed, and Avi, I'm going to go backwards because just from memory.
Perfect.
So I won't offer a definitive answer because I'm not a domestic lawyer. I would think that it would give rise to some concern. I won't say more than that. I couldn't tell you one way or the other what domestic law.
I think he was asking whether Heather Reisman should have any concerns.
Yeah. No, I will have no comment on Ms. Reisman either. But
I just want to push you on that now.
Yeah. So, well, I've made my point clear. So, I'm saying in jest.
No, I'm kidding.
So I can't really offer a definitive response to. I think that would be a disservice to you and everybody here if I even tried. The question given by Zach, thanks, Zach. This is part of what one might call the violence and inequity of international law, right? So remember, the state is the key subject on the system, and once statehood is recognized, then that comes with corollaries, one of which is the acknowledgement that the states is uniquely and independently and to the exclusion of all other states, solely sovereign in its territory. For good or ill, as a result of the events of 1948, the partition resolution of the General Assembly of 29 November 1947, which recommended partition on horrible terms that, as you say, did not at all take into account the interests of the majority population of Palestinians, subsequently ethnically cleansed in a war that followed the passage of that resolution. But as a result of that war, you have the creation of a state, Israel, through operation of what international lawyers call state secession. The creation by force of a state out of the territory of another state. So the initial act might violate the laws of that state. Say, if Quebec were to leave Canada, that would violate our local law. But if that action was recognized by other states overwhelmingly, and membership in the United Nations came afterwards, and there was treaty relations between Quebec and others, then that fact would solidify in law and create a new situation, which then comes along with other corollaries, state sovereignty and so on. Questions of borders also enter into it. So it's inequitable, but it's also the law such as it is. And this is one of the problems of, say, for Palestinians, the recognition by Palestine in 1988 of the State of Israel. Palestine recognizes Israel and has since 1988. And they've done so on the basis of Resolution 181. And since it's sort of politically accepted that they will be able to accept a state within the occupied Palestinian territory, which the flip is that you recognize Israeli sovereignty in 78% of the historical patrimony of the Palestinian people. None of that is fair. Certainly not if you're Palestinian. Unfortunately, that's law. I'm not to say there are other people who have different views, but that's how I see it. And this is the sadness of law. It can blot people out. Like First Nations, for instance. I was having a chat earlier today. We have the UNDRIP, United Nations Declaration, or Declaration on the Rights of Indigenous People, affirms that First Nations people, Indigenous people, have a right to self-determination. But if you read the fine print in article, I think it is 43 or 46, that right only goes so far. They may not exercise their right to self-determination if it impedes or violates the territorial sovereignty or political independence of the states within which they live. So think about what that means. Here in Canada, you can have local autonomy, but if you claim the right to self-determination in a state of your own, in the settler colonial state that blotted you out, quite literally, then that's unlawful. Fair? The other question, The short answer is I had a chat with Bill Shavis about this. How many of you know who William Shavis is? He's one of Canada's leading international lawyer, one of the leading international lawyers produced by this country ever. He's a dear friend and teaches at Middlesex in London, an expert on genocide. And I had this very chat with him. He was representing Myanmar, much to the great dismay of some people, in the Gambia matter. But he's written most texts on genocide. He's an authority. And I asked him, I said, it's the same question. Do you need numbers to establish genocide? He says, well, you know, I've thought about this, but I think the essence is, I won't tell you what he said, but I think the essence is you don't need great numbers. There is no threshold of numbers beyond which you know, aha, right now we've met that threshold and we know this is genocide. No. Read the statute, the convention carefully. Killing members of the group, there's no reference to numbers. Imposing conditions of life calculated to destroy in whole or in part members of the group, that says nothing of actual killing, right? So some scholars, like John Quigley from Ohio State, I was talking to him earlier today, he's of the view that the moment the Israelis ordered 1.1 million Palestinians out of Gaza City and forced them south, ostensibly for their safety, only to bomb them on their way to the south or when they arrived in the south. That act in and of itself, minus the bombing, like before the bombing of these people, qualified as genocide. I think he takes a very liberal view. I'm not sure I would say that, but at any rate, that's a view.
We'll have one last question.
Thank you for the great talk tonight. Again and again, you seem to mention that ultimately responsibility falls to the citizens to try and put pressure on their governments to act ethically, and that domestic policy and foreign policy often get dictated by groups with vested interests, and they will not act with integrity unless the population pushes them. And so then when we look at the track record for Canada, I'm not sure how germane the example of Russia and Ukraine is, but I certainly think that with Indonesia, Canada supported Indonesia throughout Suharto's regime, and I believe he purged 1 million Indonesians after the US-Canada-backed coup that installed him, on the pretext that they were communists, and those death squads are chronicled in the documentary, The Act of Killing. And then Canada continued to support Indonesia when they genocided the East Timorese. And even to the point that our government pressured the CBC, which is our public broadcaster, not to cover the genocide of the East Timorese because it wasn't newsworthy. And I was at SFU at the time, and my university was being paid federal funds to train engineers in Indonesia while the genocide was happening. So, and then with Yemen, we've got $14.5 billion worth of light armor tanks from Canada, and that's gone through. So my question to you would be, in a country where our own right to dissent was stripped from us, and we weren't allowed to protest the mandates, everything in Ottawa, and there was some execrable violence. I watched footage of people being beaten with bats and rifle butts and trampled and kicked in the face, and just horrible on the part of the police. And in this country where we support Saudi Arabia after the death of Khashoggi with all of this weaponry that's going into Yemen, what do you think, even if you're not engaged in advocacy, what do you think we can do to push our academic intellectuals and our elected representatives to actually have the courage of their convictions and to sort of apply their ethics in an integral manner, not ignoring the sort of crimes of NATO and everything? I mean, you mentioned 4 elements, after speaking about the tension between the UN's position, the political consensus favoring negotiated withdrawal. The last one was about the collective, when collectives engage in sort of in these crimes. And clearly that's the case for NATO. And we just go along giving assent to what NATO does everywhere. It makes no sense. So how do you think that we can turn the tide on this, especially at universities that are completely complicit in the most egregious crimes consistently, all the good schools?
Yeah, very good question, for which thanks. I'm going to answer it. Well, actually, Avi, did you want to take another series?
No. I think we're sort of past time. So
all right,
we should
okay.
wrap it, and
Oh
Brenda's gonna
wow, I
wrap.
could do this all night. I mean, how often do you have, I think the first place to begin, this will sound perhaps not substantial, but and there is meaning in these words, I think, is to just begin with the critical mind. The university is the place where people are meant to ask questions. We're doing that now. You may not agree with what I say, and that's perfectly all right. And, I welcome challenge, and ideally we should be able to challenge one another and think more critically about the world around us. But that vocation to be critical doesn't stop at the university. It has to continue. And whether you're out on the street protesting, which to my credit, I do. No, I actually did. I was actually hard on myself earlier. I do that. But whether you're out on the street protesting, or you're writing a letter to your MP, which I was doing just the other day with others, or giving evidence, as I did at the invitation of the NDP member for Edmonton, Heather McPherson, I was giving evidence to the Senate Committee on Foreign Relations the other day, on Yemen, on Palestine, and so on. Whether you're doing it at that level or you're doing it on the ground level, you have to do it. And the nice thing is, despite what you paint, the difficulties of doing it, my dear friend, we also live in a place where we can do it. There are people in the world who don't have access to a free and democratic society ostensibly. And so there are ways we can challenge that, despite your critical view on how things, our ability to speak truth to power has been limited, in certain quarters. Press on, man. That would be my view, and I think we all must do. Each and every one of you are doing it right now. I mean, you're engaged with me, in a sense, and you will either agree or disagree, but that will continue and ripple. And we must speak truth to power. And I borrowed that from Professor Said, who has been a mentor to me in my own life. And so you must do that. There are many different actions. I won't now lecture you on those things. The point is to just remain critical. And again, taking from Said, humanist, right? What's good for the goose is good for the gander. If we have rules and laws and order, it must apply to all. And if it doesn't apply to all, then it's something else. It's not order. It's not rules. It's not law. It's something else. Don't be fooled by those who tell you we care about law, as our government does when they're selectively applying. So press.
Thank you, Ardi.